Last matter to come before the court this morning is the guardianship of Fourough Bakjtiar. And both parties will have 15 minutes which to present their case. Through the appellant, you should retain some of that time. Let me know when you come up to the podium. I'm keeping track of the clock and keep you apprised of the passage of time. We have your briefs and we're ready to proceed with the order.
Hello, Your Honors. May it please the court, my name is Matthew Mersalk and I represent Bakjtiar Sagafi. I'll request a full 15 minutes for argument and reserve 4 minutes for rebuttal. Bakjtiar filed the motion to intervene in the guardianship of Fourough Bakjtiar. Fourough is the mother of Bakjtiar. Zachary Simenoff, an attorney, is the guardian. Fourough has severe dementia and has for some time. Currently, no family member is a party to the guardianship matter, and the family has largely been really left in the dark regarding the medical and financial condition of their mother. As a result of the lack of information, my client filed the motion to intervene. My client is really seeking basic information such as the ability to obtain medical records, the ability to access appropriate court filings regarding his mother, and the ability to participate as a party. I think it can be recognized that any son would have an interest regarding this information concerning his mother. The probate court, however, denied that motion. They stated explicitly that there's no recognized right or need to intervene in a guardianship. That determination is directly at odds with Civil Rule 24. And I should mention that my client moved to intervene under Civil Rule 24. Civil Rule 24 states, upon timely application, anyone shall be permitted to intervene in an action, read from subsection 2, when the applicant claims an interest relating to the property or transaction that is the subject matter of the action, and the applicant is so situated that the disposition of the action may, as a practical matter, impair or impede the applicant's ability to protect that interest, unless the applicant's interest is adequately protected by represented parties. And the Supreme Court has stated that Civil Rule 24 should be liberally interpreted in favor of intervention. So here the court simply determined that Civil Rule does not apply and didn't engage in any further analysis of Civil Rule 24, and it's, if the elements were met. So we would certainly maintain that the elements of Civil Rule 24 are met. My client has an interest in his mother's welfare. The disposition of the action is impaired. Impairs his ability to protect his interest because he can't participate as a party. He doesn't have medical records. He doesn't have access.
What
to
is his interest?
It's his mother's welfare that he's a concern.
Which is supposedly being protected, right? That's what the court is involved with.
Correct. The court is the superior guardian. However, as one of the cases we cited is in Ray Sweeney, that's a 2016 case from the 8th District, where that issue of the court being the superior guardian was raised, and the court essentially rejected that argument, stating that where it's a family member, that is a sufficient interest to intervene. And I think that the fact that the court is a superior guardian, there's really nothing out there that would suggest that that's exclusionary of somebody's Civil Rule 24 rights.
Did your client bring in his motion, did he bring any concerns to the court that he was concerned that his mother's financial status was being compromised, or her health history or her health was being compromised?
There's a long factual section in the court, my client's motion to the court, and in the appellate brief. I'm a little bit new to this, so there's a lot of minutia in that, but there's essentially a divorce between his parents, and it was a really high net worth divorce, and this happened after his mother was declared incompetent, and it really resulted in a lot of money going into the guardianship, and now the family doesn't really, they've essentially been shut out on knowing what's going on with that and what's going on with
I'm sorry, go right ahead.
No, that's okay.
But I don't understand, hasn't this all been litigated many, many times?
Well, there are multiple, corresponding, matters. This, and from what we're here today, is regarding the court's denial of the motion to intervene.
No, I understand, but that's why I was asking specifically about what interest there is involved here, because I think this is maybe the 4th time I've sat on this case involving these parties.
Right, and well, I believe this is, and again, I'm a little new to this, but I think it's Bakjtiar's first and really only action in these matters to, gain information regarding his mother. So,
Does he, in general, does a person have access to any probate records at all? I mean, and accounting, financial accounting, aren't those filed in a case? Isn't that public record?
we would assert that, but we have not had, my client has, to this date, have not had access to the file.
Is it a public record?
I would assert that it is, and that's.
But he hasn't gone to see it?
No, they've been denied access to the file. We filed multiple motions for access to the guardianship file. Those have been contested by the guardian. It appears as though that may be resolving, but it's been a long time. I believe the first motion for access to the file was filed sometime around November of 2017. We just recently are in the process of getting access to the file. There's been an indication that we will get it, but some of the documents are essentially going to be sealed and marked confidential. But at the end of the day, we still don't have the file as of this date, and it's almost going on a year. So his interest is knowing his mother's medical condition, protecting his mother's interest, and just basically being a son. So I want to discuss this case in Ray Sweeney a little bit because it's very on point. In that case, a daughter had concern that her mother was not being adequately cared for by her brother, who was the guardian. So in this case, she filed a motion to intervene. The motion was denied by the court, but the court did essentially somewhat recognize her concern, and they assigned a investigator to the case. They further set the case for review hearing, and they provided recommendations for communications and visitation guidelines. However, on appeal, the 8th District overturned the court's decision to deny her motion to intervene. The 8th District finding that a daughter's concern for mother and desire to obtain medical records is a sufficient interest to intervene in a guardianship. And similar to this case, where the decision by the court references that without the need to intervene, our client can still file these requests. Again, that's not exclusionary of somebody's rights under Civil Rule 24. And while my client appreciates the court's willingness to work with him on these things, he still has the right under Civil Rule 24 to move to become a party, and that is a right that's been applied to guardianship, such as this case. So, Appley's brief has kind of characterized my client's attempt to obtain medical and financial information regarding his mother as a fishing expedition to satisfy his own curiosity. Again, I would just impress upon this court that this is a son who's seeking information on his mother. This is not like a nosy neighbor or something. It's someone who has a direct relation to the ward. And again, in the case in Sweeney, while it does state that a family member does not automatically have the right to intervene, it does make a clear distinction between situations where you have a family member seeking to intervene versus somebody who's not a family member, so it's clearly a consideration. Appley's brief also asserts that there was no pleading attached to our motion to intervene, which is required under Civil Rule 24. However, in a guardianship matter, it's distinguishable from an adversarial case where we'd be filing to intervene to answer or something like that. So there was no proposed pleading that we wanted to
So then why does the rule require a plea?
That's what it states, but it's a rule that would be a broad application. It's simply not applicable in a guardianship proceeding, though.
But how do we determine what is or is not applicable if it doesn't specifically say a guardianship proceeding to begin with, and then it said a pleading? So an argument could be made that it only applies to adversarial proceedings.
Well, I think that the 8th District would have essentially kind of already dealt with that issue when they've permitted these to be required. There's also another case where a motion to intervene was denied on standing grounds, and it was denied because the parties didn't file to intervene at the trial court level, but the court never made any issue of whether, they didn't state that Civil Rule 24 doesn't apply to guardianship. Further, that argument regarding the attachment of pleading was not raised at the probate court level, so there's waived appeal. So, appellant is, requesting that the court reverse the probate court's decision and permit Appley to intervene as a party in the guardianship action. However, if the court's not willing to do that, I would assert that at a minimum, it really can't be argued that the probate court decision was not an error in that it refused to recognize Civil Rule 24 as it applies to guardianship. So at minimum, it should be remanded back to the probate court with instructions that they apply Rule 24 to the motion and consider the elements set forth in Rule 24 for intervention. So that's all I have.
Thank you. You'll have 5 minutes actually. It's left.
Good afternoon, and may it please the court. I'm Eric Zabrins, representing the guardian appointed by the probate court, Zachary Simonoff. This is actually the 7th of 9 different appeals filed by various family members of the Sagafi family regarding the guardianship of mother or wife, as the case may be, Fourough Bakjtiar. The probate judge did not abuse his discretion in denying this motion to intervene, contrary to what opposing counsel has argued to the court. The probate judge did take the motion to intervene under Rule 24 into account. He denied that motion and stated very clearly in a sentence from his order that was not quoted by the appellant when the appellant purported to quote the order in his brief, that any of the relief that this particular son is seeking in moving to intervene will be entertained and heard by the court without the necessity of an intervention. So if appellant is relying, as counsel has argued more than once to the court in brief and this afternoon, on the requirements of Civil Rule 24A, the essential element of Civil Rule 24A that says intervention of right is granted only when the failure to intervene will have an adverse impact on a material right of that party. Here, there will be no material impact, adverse or otherwise, on the appellant's rights of whatever the appellant wishes to raise when the probate judge says you will be allowed to make your arguments and make your application and seek whatever relief you want in this proceeding without the need to be denominated a party by way of intervention.
And I want to make sure I understand, counsel. Are you saying that's a general rule that's that case law and that the statutes provide for in a guardianship proceeding? Or are you saying in this particular case that the judge was extending the ability to participate to this family member?
Your Honor, 2 points. One is that the case law and the statutes clearly allow a probate court to receive information and consider arguments and information from non-parties. It's done all the time. The case law says that a guardianship proceeding is an interim proceeding where the only appropriate and necessary parties are the court itself as the superior guardian, any guardian that the court appoints pursuant to that superior guardianship, and the ward herself. Those are the required parties. But the courts say the court is permitted to receive information and act on that information from any source that the court feels is competent and reliable. So that provides the vehicle for a probate judge to consider in a guardianship proceeding the kind of information that appellant wishes to present. In this case, without, I think, precedent or need for precedent anywhere else, the probate judge said, but I am going to listen to you and you may present your request for relief or for any remedies that you are requesting from the court without the need to formally intervene as a party. And that's the part of the order that was omitted and what I'm complaining about being omitted because the judge said, and let me quote it here from the brief, the judge said, Mr. Sagafi may request the court for any of the relief he has listed in his motion to intervene without the necessity to intervene.
When I hear that, though, it sounds like almost a de facto intervention.
Well,
That said, I'm denying you the formal right, but basically I'm making you a party so you can get whatever you want, if I think it's necessary.
I understand that, Your Honor, and that may well be the case. But there's no reason to find that to be an abuse of the court's discretion because in reliance on Civil Rule 24A, the requisites for Civil Rule 24A have not been satisfied in this case, and the court so found. The court found not only have they not been satisfied, but there's no need to satisfy them under the circumstances of what the probate judge is willing to allow.
Except that other parties, like you said, the guardian, for instance, could file an objection and say this person is not entitled to this, or this is not appropriate in the guardianship proceeding, or whatever, even if the trial judge was saying, I'm going to allow it.
Well,
And then if it was appealed, what standing does he have if he hasn't been granted intervention?
I will tell you that the guardian may oppose on the merits the relief that may be requested by Mr. Sagafi in further proceedings before the court. But the guardian will not be objecting to or arguing that the court didn't have the proper right to say, I'm going to entertain this application
But again, are
without
you saying,
intervention.
I'm sorry to interrupt you, but again, are you saying in this particular guardianship, this guardian won't, or in general, a guardian doesn't have the right to object procedurally? See, it's,
I understand your Honor's question. It does get that way because of what the probate judge did by saying he was going to entertain this relief. If he had not said that, intervention still would not be appropriate and still wouldn't have been an abuse of discretion for the court to deny intervention, because the Sweeney case does not say what the appellant wants to twist it and expand it to say. It's right in paragraph 26 of the Sweeney Court's opinion by the 8th District. We recognize that while Julie, that was the sister of the ward in that case, being related to the ward does not in and of itself confer party status upon Julie, does not in and of itself confer the right to intervene, and that's what the Centrusic case, an Ohio Supreme Court decision, also says. And the Sweeney Court relied upon Centrusic for the conclusion that a family member doesn't, just by dint of being a family member, have an automatic right to intervene in a proceeding. So Sweeney does not expand to the kind of argument that the appellant wants to make of it here. And when he argues that he's been denied access to the probate file, I'm sorry, counsel, I recognize, is new to this case, has not been with it over the years, but that is simply untrue. There has been absolutely no denial of access by the court or by the guardian to the file or to any information about the circumstances and condition of the ward. The confidential medical details, confidential financial details have not been disclosed. That is true. But there is no need for the disclosure of those confidential medical and financial records in order to provide an appropriate amount of information, such as appears in the guardian's periodic reports that the guardian makes to the probate court. And when the appellant argues that he's just a son seeking, of course, to know the condition of his mother's well-being out of the appropriate love and respect that a son owes to his mother. This is a son who has not visited his mother not even once in the nursing home, not even on her birthday last spring, when the guardian 3 times asked the probate court to specify in an order that visitation be permitted. The probate court 3 times told the family, yes, you should visit, go visit. We want you to visit. The mother's birthday is coming up. She may not have another birthday. And not one family member, including this appellant, went. So, I'm sorry, but that's not an argument that provides justification for finding that the probate court's ruling in this case, denying this son intervention rights after other sons and the ex-husband have filed these seriatim motions seeking access to all this confidential financial information. It is a fishing expedition. They want to nose into how much money she has, and that's not an appropriate reason to intervene in a guardianship. So unless the court has further questions, I would respectfully request that the court affirm the probate court's ruling in this intervention question on finding that it is not an abuse of the probate court's discretion under the facts and circumstances. Thank you.
Attorney Masalka, you have 5 minutes, sir.
Thank you, Your Honors. As I noted in my argument, the decision does state that Mr. Sagafi may seek any of the release listed in his motion to intervene without the necessity of a motion to intervene, but that leaves an ambiguity as to my client's status in the party, and as noted by the court, even if he were permitted to come present evidence at a hearing and participate, he couldn't appeal that decision if he's not a party, he doesn't have standing to do that. It further raises other questions of, how is my client getting notice of what's filed, how is he, permitted to present evidence. As this court's noted, this matter in general has had a long history, and I think that the ambiguity regarding his status as a party will only encourage more argument. So with regard to the file, my client has not been able to get access to the file, and his motions to access the file have been, been contested, and we're still waiting on full access to the file. So I would really just point the court to the plain language of the decision, which states there is no recognized right or need to intervene in a guardianship. And I would highlight the use of the word "a," referring to guardianships. It's clear that there is a recognized, that Civil Rule 24 very much does apply to guardianships, and appellate courts have found that. And that the courts, their refusal to consider Rule 24 was an error, and so that my client has satisfied the requirements under Civil Rule 24 to become a party, and at minimum, though, it should be remanded back to the court with instructions to consider Rule 24 as it does apply to guardianships, such as the one before the court today. So that's all I understand.
Okay, thank you both for your presentations today. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides as well as posted to our website and mailed to the Supreme Court. Thank you, gentlemen.